Yes.
Good morning.
Good morning, ma'am. How you doing?
Good. What is your name?
Rolando Baerga. Like Baerga with
Okay,
yeah,
so we have your attorney here. We're gonna get started with your revocation hearing, okay?
how you doing, boss? How you doing, mister?
Good morning.
Don't mind me, I'm a little nervous, you know.
That's fine. It's good that you care.
Yeah, I do, man, you know.
Yeah. All right, we'll get going with the hearing now.
All
Okay.
right, good morning. My name is
Good morning.
Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Rolando Baga 308099. Today is Tuesday, February 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Rolando Baerga, B as in boy, A-E-R-G-A.
And your inmate number.
308-308-099.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
Good morning, Mr. Good morning, Mr. F.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there's a preponderance of evidence to support one or more of the violations of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Baerga, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I promise.
Okay, thank you. You can lower your hand. Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I just want to take full responsibility for my actions, and I just want to move forward.
We're definitely going to get there where you'll have an opportunity to speak if you choose to do so.
Okay.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am. Yes, ma'am.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On November 29th, 2024, you were observed by Waterbury Police Department officers operating a motor vehicle with misused license plates. Waterbury police officers stopped your vehicle and you gave them a false name and date of birth. While conducting an inventory search of your vehicle, Waterbury police officers located a purple plastic capsule containing a white rock-like substance, later tested for confirmation and identified as crack cocaine. You were subsequently charged by Waterbury Police with operating an unregistered motor vehicle, improper use of marker, license, and registration, possession of controlled substance first offense, interfering with officer and resisting arrest, illegal operation of a motor vehicle without minimum insurance, and operation of a motor vehicle without license. The state has filed the following exhibits. Exhibit A, Connecticut remand to custody. Exhibit B, signed conditions of parole. Exhibit C, notice of parole violation and parolee rights. Exhibit D, parole violation report. Exhibit E, Waterbury Police Department reports. Exhibit F, photographs. And Exhibit G, State of Connecticut Judicial Branch documents. The state has filed an addendum to Exhibit D, which states on January 3rd, 2025, Mr. Baerga was found guilty of possession of controlled substance first offense and interfering with an officer. Mr. Baerga received a sentence of unconditional discharge on both charges under docket ending in 069. The charges of operation of an unregistered motor vehicle, improper use of marker, license, or registration, illegal operation of a motor vehicle without minimum insurance, and operation of a motor vehicle without license were dismissed. Counsel, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
Yes, we have.
And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted. Counsel?
As a result of the conviction and misdemeanor unconditional discharge, we have no comment as to the preponderance standard.
Thank you. I'm just going to take a moment before I announce my findings.
Ms. Honda, I just want to say, I take full responsibility. I just relapsed. I was doing so good, and I just relapsed. And I was doing so good working.
At the end, you'll have an opportunity to discuss how you feel and that, but she's just going to make her findings now. Okay, sir?
Okay.
Thank you. Regarding charge 1, obedience to the law, I make a no finding on the following charges: operation of unregistered motor vehicle, improper use of marker, license, and registration, illegal operation of a motor vehicle without minimum insurance, and operation of motor vehicle without a license, as these are motor vehicle infractions. I make a finding on the rest of the charges listed in this violation based on Mr. Baerga's conviction, as well as state's exhibits B, D, E, and G. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Yes. This is my client's first violation of this period of probation. He's been remanded since November 29th, so he's been over 2 months. This is nonviolent. The car was searched, and not on his person, but there was one small capsule of crack cocaine. He's been very forthcoming about the fact that he relapsed, and that he understands the error of his ways. There were no graduated interventions or sanctions whatsoever. He's single. He's 38 years of age. He receives his primary support from his 6 brothers and 2 sisters. One of his brothers is a teacher. He also receives significant support from the mother of his 4 children. He's working to reconnect with both his children and the mother of the children. They were enjoying attending the Y with his son in the past. He completed the 11th grade at Kennedy High School in Waterbury. At the time of his remand, he was working at Whole Foods Distribution Center. He had been there since April. He participated in the Explore program and completed 21 of 26 sessions, so he was doing very well with that. He also, while incarcerated, twice weekly with Counselor Hudson, does the New Thoughts group. He's also a tier man, and he has signed up for school to obtain his GED, and he reads materials on addiction. Upon reinstatement, he'd like to be re-sponsored again by his sister. The information is there. He was previously sponsored by her. He wishes to get his GED, and he's eligible to return to his full-time position at Whole Foods in Cheshire. I don't believe this is such a significant, serious violation of his parole conditions to require further incarceration. I think he will do very well back on parole. Like I said, there were no sanctions. This is nonviolent. It was a very, very small amount of drugs, and he is very remorseful. Thank you for your time and consideration. We'd ask for a release at the soonest possible board date. Thank you.
And I
Thank
would
you
also
again.
like to give Mr. Baerga, do you want an opportunity to speak, or did your attorney cover everything for you?
He covered mostly everything. Like I said, I just want to take full responsibility. Like, I'm just shameful for what I did. That's all. I beat myself up every day for it, but just trying to better myself from it, Miss Sanders. Honestly.
All right, thank you.
Thank you, Rolando.
Yes, ma'am.
I'm going to take a moment before I announce my recommendation.
Yes, sir. I appreciate you again.
Mr. Baerga, being that this is your first violation, you were in the community for about 8.5 months with no misconducts. Taking all that in count, and as well as the conviction you did receive during this violation, I recommend revoke and reparole on February 28th, 2025, which is an approximate 3-month sanction with the following conditions: no consumption of alcohol, domestic violence, a general no contact with Vincent Tillery, no contact with victims CC and HH, halfway house placement in the event that is needed. And I know you have your sponsor to your sister house, but in the event that it is needed, I did put the halfway house placement. And my findings and recommendations will be given to the board. You will receive the official written decision from the board, and your board review is scheduled on February 13th, 2025. So on February 13th, the board is going to take a look at your case. My recommendation is February 28th, 2025. So the board can lower my recommended sanction. They can adopt my recommended sanction, or they can exceed my recommended sanction, being that you're on supervision until January 2026. Okay, but you will receive notice in writing within the week. Okay, Mr. Baerga?
Rolando, this is so if they accept your recommendation, that's what they usually do, okay? You won't be released on the 28th. You might, but it's because you're on discretionary parole, it's an on or after date.
Yes,
So call me on Valentine's Day, and I'll let you know what happened. Okay?
All right. Hey, thank you again.
Take care, sir.
Thank you.
Thank you. Good morning.
Good morning.
Good morning, Mr. Anderson.
Morning. How you doing, man?
Hey, how are you?
Morning.
My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Thomas Anderson, inmate number 276886. Today is Tuesday, February 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Thomas Anderson, 276886.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Anderson.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony of today's hearing will be taken under oath. Mr. Anderson, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you.
That's what. All right.
First, I will read your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On September 3rd, 2024, New Britain police reported you had a verbal altercation with the victim at your Parole and Community Services approved residence, located at 3 Peace Center, New Britain, Connecticut. Per the police report, the verbal altercation was about something the victim saw on your phone. After the verbal altercation, you left the residence and texted the victim to gather your belongings. When you went back to the residence, you forced the front door to open, causing damage. You then left the residence again on foot. Officers looked for you and were found in the area of 475 Arch Street in New Britain, Connecticut. When an officer ordered you to come to him, you responded, "I didn't do anything," and began to run away. After a brief foot pursuit, you were detained by New Britain officers. When officers interviewed you, you stated that you just wanted your belongings and admitted that you may have forced the apartment's front door open. You also stated the verbal altercation never became a physical altercation. Officers observed that you had no injuries. The victim also stated that the verbal altercation never became a physical altercation. Subsequently, you were arrested for disorderly conduct, criminal mischief third, and interfering with an officer. Charge 2, behavior management program. Per the Explore Progress report dated September 5th, 2024, you had one unexcused absence on August 22nd, 2024. You were arrested and remanded on September 3rd, 2024. You did not complete the Explore Domestic Violence Program. The state has filed the following exhibits. Exhibit A, Connecticut Conditions of Parole. Exhibit B, Connecticut Board of Parole Remand to Actual Custody Order. Exhibit C, Notice of Parole Violation and Notice of Parolee Rights. Exhibit D, Parole Violation Report. Exhibit E, New Britain Police Report. Exhibit F, State of Connecticut Board of Pardons and Paroles Decision Information Summary. Exhibit G, State of Connecticut Judicial Branch Pending Case Detail. And Exhibit H, Judicial Branch Court Support Services Division Explore Progress Report. The state has found an addendum to Exhibit D, which states on January 13th, 2025, Mr. Anderson was convicted of interfering with an officer and resisting arrest and was sentenced to 364 days jail, execution suspended after 4 months, followed by 18 months conditional discharge. The charges of disorderly conduct and criminal mischief third were nollied under docket ending in 706. Counsel, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
Yes.
Defense has filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted. Counsel?
Yes, thank you. In regards to charge 1 under obedience to the law, my comments are the addendum is stated accurately. I would just point out that my client has served that 4-month sentence. In fact, he's been held for approximately 5 months at this point. I would also point out that there is no allegation of any physical violence. It was a situation where there was a verbal altercation. My client attempted to de-escalate that situation by walking away. He simply returned only to get some belongings to continue to walk away and have a cooling off period. And I think that's important to note. He was not convicted of a domestic violence crime. He was convicted only of an interfering charge, which he entered into a plea agreement. In regards to charge 2 under behavioral management program, we would submit there's insufficient evidence to support this charge. One, it's an impossibility that my client would have had an opportunity to successfully complete this program due to the fact that he was remanded. If you look at the document Exhibit H, which is the progress report submitted in support of the charge, the progress report actually just shows that my client had one unexcused absence and was actually attending that program. It does not indicate that my client was unsuccessfully discharged from that program. He was in fact going to the programming. The only reason why he stopped going to the program was because he was remanded and incarcerated, and therefore it was impossible for him to continue with that program. Nothing further as to the charges.
Thank you. I'm just going to take a moment before I announce my findings. Regarding charge 1, obedience to the law, I make a finding based on Mr. Anderson's conviction as well as states exhibits A, D, E, and G. On charge 2, behavior management for domestic violence, I make a no finding as the state failed to provide sufficient evidence to prove Mr. Anderson's actions meet the elements of this charge. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, thank you. My client is 42 years of age. He's single, though he's in a committed 8-year relationship. He did just recently have his first child, who was born on January 28th of 25, which was a little bit earlier than he had expected. And unfortunately, he's incarcerated during that time period. He did obtain his GED. He began classes towards his cosmetology license. In the community, he has the support of his girlfriend, who was his sponsor. He was in the community for approximately 6 months prior to this violation, and this is his first violation of parole. He has now been incarcerated for approximately 5 months. I believe it's 5 months today. He was engaging in the Explorer program, and we would indicate that by all means he was actively engaging in that programming, and had he not been remanded, he probably would have successfully continued with that programming and hopefully would have been on his way to completing that program. Also, while he was in the community, he was gainfully employed. He was working at Pendergrass Recycling in Newington for approximately 3 months, also working at IHOP in Berlin for approximately 1 month. He had successfully completed Halfway House Renaissance East in Waterbury. He completed an IOP that was 6 weeks, 2 times a week. He was on GPS the entire time that he was on parole supervision, and as you can see, there was no violation indicated of that GPS bracelet, so he was fully compliant with that. He never provided any dirty urines, though he was tested bi-weekly throughout his period of probation. He successfully completed the Halfway House and was able to transition to a sponsor. If he's reparoled or when he's reparoled, he'd like to return to his sponsor, who is Kember Jones. And her information, I believe, is contained within our Defense Exhibit 1. If it's not, I can provide it because I'm actually not certain if it is. Though I did advise my client that it's an unlikely return in light of the fact that she was listed as the alleged victim in the case, but that is his wish, as they just did both have their first child together. And it's important to him that he be there to raise his child and he continue with that relationship. Secondarily, he'd like to be placed in a halfway house in Middletown as a halfway house choice. And then if that's not available, a halfway house in the Hartford jurisdiction. Parole should have the information for Kember Jones. I can provide it, but that's where he last sponsored to. So they should have that information. Let me know if you need it.
I do need it because I have here, based off of the Exhibit 1, it was I have residential for Halfway House in the Norwich area because of the location. That's what I have based off of the Exhibit 1.
Okay, so I believe it's Middletown, is that correct?
Yes, ma'am.
Okay, Middletown and Hartford, I apologize for that. And if I can just give you the address, just because it is his first choice for Miss Jones, it is 3 Peace Court, first floor, apartment 3, New Britain, Connecticut, 06150.
And what's her phone number?
860
Yep.
729 9916.
And her name, is it Kimber Jones?
It's Kember Jones.
Okay. So I have her first name is Monique. Is that not accurate?
That's her middle name.
Middle name. Okay. Got it. Anything further, Council?
Yes. And so by way of education, he'd like to return to cosmetology school. He also indicates he has his employment to return to at Pendergrass Recycling. He's amenable to all treatment recommendations, and that would include parenting classes and couples therapy if that were deemed appropriate by parole. I would note that the parole officer did recommend a strict no contact order with Ms. Jones, and we certainly would be objecting to that in light of the fact that there was no conviction here for a domestic violence offense. My investigator did reach out to Ms. Jones and was able to communicate with her, and it's her wish that that my client return back home with her. She indicated that she does need him. She needs his support, that they've never had a history of any physical domestic violence in the past, and that this simply was a verbal altercation, and that she would like him home to help her raise their child. Again, it's her first child. It's his first child. They have been in a relationship for approximately 8 years, and that is their wish. And that's it. Nothing further. So we would be asking that he be re-paroled at the next available date. Thank you.
Thank you. I'm going to take a moment before I announce my recommendation.
And one thing, if I could just point out, I think it's important to note, if the court felt as though it was appropriate, Mr. Anderson would have been convicted of a domestic violence offense, and there would have been a protective order in place. And that certainly was not the case here. There is no protective order issued by the court. So I don't see any need for parole to keep these people apart, especially in light of the fact that they have a child that was just born a week ago. Thank you.
Thank you. And Mr. Anderson, I see that you were on supervision for about 6 months with no misconducts. This is your first violation while being on special parole. Taking that into account, as well as the conviction you did receive this violation, I recommend revoke and re-parole on February 13th, 2025, which is an approximate 5-month sanction with the following conditions: no consumption of alcohol, domestic violence, no contact with victims AS and AF. So I'm going to make note of the request for you to have to have the stipulation of no contact with Ms. Jones, but I am putting as a condition a general no contact with KJ without the express permission of your parole officer and TW. So as long as your parole officer says you're allowed to have permission or contact with her, you can. These conditions are also going to go before the board. So they can change this condition as well, just to keep that in mind. So also the other conditions: halfway house placement, mental health evaluation, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive the official written decision from the board, and your board review is scheduled on February 13th, 2025. So the board can agree with my sanction, or they can exceed my sanction, being that you're on supervision until June 30, 2034. If the board does exceed my recommendation, then another hearing will take place. But if they agree, you'll be released on February 13th, 2025. Okay.
Thank you.
Anything else? Any questions?
You said that I'm kind of lost with the TF. You said they have permission from them for
right. So the conditions. So my recommendation is that you have no contact with Ms. Jones without the express permission of your parole officer. So as long as your parole officer agrees that you're allowed to have contact, you guys can have contact. I know that's your first choice for placement, but again, it's going to be up to your parole officer to approve that. Okay, but again, this all of my recommendations, my recommendation for a sanction all goes before the board on the 13th. So they have the opportunity as well to change that condition as well. They can keep that or change it to a no strict contact. It's up to the board because they have the final, make the final decision.
Right, so I would go to the halfway house on the 13th.
Correct.
All right.
Yeah, that would be,
Thank
as long as the board agrees with the recommendation, yes.
Right, thank you, man.
No problem.
Sonia, thank you. I appreciate it.
You're welcome. Good luck,
Thank you very
okay?
much. All right,
All right.
thank you, man.
All right, bye.
Enjoy your day, man.
Thank you.
All right.
Okay, so I'll see you back at 10.
Yep, thank you.
Okay, thank you.
Hearing examiner Saunders.
Yes,
So you're not having another hearing until 10, right?
correct.
Okay, I just didn't know if the schedule changed at all. Okay, thank you.
Nothing changed. Nope, we're still on schedule.
Okay, thank you so much.
Thank you. Good morning.
Good morning, how are you?
Good. We should have Mr. Wright, Mathis, and Santana.
I'm waiting on Mathis. I have Wright and Santana right now.
Okay, let's start with Mr. Wright. Is that okay, Attorney Jones?
Yes.
Okay,
Thank you.
you're welcome. Wright? I'm getting this one here.
Good morning, Mr. Wright.
Good morning.
My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Vincequan Wright, inmate number 404-743. Today is Tuesday, February 4th, 2025. This hearing is being conducted via video of the Board of Pardons and Paroles Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Vincequan Wright, inmate number 404-743.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Wright.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Wright, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. You can lower your hand.
That's nice.
Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On July 19th, 2024, you were involved in a motor vehicle accident. After an accident, reconstruction, and investigation, it was determined that you were in violation of the law by members of the Meriden Police. You were intoxicated and driving in excess of 108 miles per hour. You then crashed, causing property damage. A search of the accident scene at the time of the accident resulted in finding crack cocaine. A warrant was applied and approved for reckless driving, DUI, 4 counts of criminal mischief third, failure to wear seatbelt, and possession of controlled substance. Subsequently, you turned yourself into Meriden Police and you were allowed to bond out. Charge 2, no consumption of alcoholic beverages. You were found to be intoxicated while driving by Meriden Police with a BAC of 0.19. This is in direct violation of condition number 7, alcoholic beverage consumption, which states throughout your period on parole, you are prohibited from consumption of alcoholic beverages. The state has filed the following exhibits. Exhibit A, Connecticut conditions of parole. Exhibit B, Connecticut Board of Pardon and Parole remand to actual custody order. Exhibit C, notice of parole violation. Exhibit D, parole violation report. And Exhibit E, all 9 Meriden police reports. The state has filed an addendum to Exhibit D, which states on January 6, 2025, Mr. Wright was convicted of 1 count of criminal mischief third and received unconditional discharge. The charges, 3 counts of criminal mischief third and possession of controlled substance were nollied under docket ending in 679. Regarding the charges of reckless driving, operating under the influence, and failure to wear seatbelt, the court ordered Mr. Wright to successfully complete the impaired driving intervention program under docket ending in 229. In order to allow Mr. Wright to participate in the court-ordered diversionary program, PCS requested to withdraw those charges and will not be considered at today's hearing. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted. Counsel?
Yes, thank you. In regards to charge 1 under obedience to the law, my only comments will be that the addendum is stated accurately and that my client did enter into a plea agreement regarding that criminal mischief third, received the unconditional discharge, and that charge was a result of an motor vehicle accident, as you're aware, where there was property damage, I believe, to a fence in some yard area. And that is the basis of that plea. I would note that my client made upfront restitution in that matter, and therefore the court did sentence him to an unconditional discharge based on the fact that he was able to make that restitution. Nothing to add in regards to charge 2.
Thank you. I'm going to take a moment before I announce my findings. Charge 1, obedience to the law. I make a finding based on Mr. Wright's conviction, as well as states exhibits A, D, and E. On charge 2, no consumption of alcoholic beverages, I make a finding based on states exhibits A, D, and E. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Yes, thank you. My client is 36 years of age. He's single. He does have 2 children, a 3-year-old and a 7-year-old. He does have family support in the community by way of his mother, father, his girlfriend, and his brother. He last completed the 11th grade, though he tells me that he would like to obtain his GED. He was in the community prior to this violation for approximately 2 years. And during that time period, he was released to special parole on November 23rd of 22. He successfully completed the Connection halfway house program. He was sponsored by his sister in the community. He was able to work through a temp agency at Stan Chemical, and he also was a stay-at-home dad. He worked with his father, also doing automotive jobs, as his father is a mechanic. He worked at Black Diamond detailing cars in Meriden. He does have the intention to obtain his CDL through NETS when he is back out in the community. Again, as you're aware, he was in a motor vehicle accident that was the subject of this violation, essentially. That accident took place on July 19th of 24. He was arrested and he did bond out. He was placed on a GPS bracelet by his parole officer. He wasn't remanded until November 25th of 24. He remained in the hospital for approximately a month and a half following that accident, as he did have extensive injuries. He then relocated to Apple Rehab, where he was able to rehab there for approximately 1 month. And that would be the reason why I believe the parole officer allowed him to bond out and remain in the community, because of the significance of his injuries. And I would just note that during that time period, he certainly didn't have any violations. He's asking, upon being re-paroled, that he again be sponsored by his sister. I believe Ms. Dickerson's information is contained within Defense Exhibit 1. By way of employment, he certainly is in a situation where he needs to continue to rehab. He did suffer substantial injuries. He needs to be able to rehab those injuries, obviously participate in that impaired driving program that the court ordered. So he is going to have to put finding employment on the back burner until he is able to get himself kind of back on his feet. But in addition to knowing that he has to rehab his injuries, knowing that he has obligation to the court, he would like to obtain his GED. He is amenable to all treatment recommendations that Parole has, including any community-based programming. Based upon the length of time that he was in the community, the fact that he was doing well for a period of time, that he did receive a diversionary program in court, and that obviously he has that obligation to the court to complete that program, we would be asking that he be re-paroled at the next available date. Thank you.
Thank you. I'm just going to take a moment before I announce my recommendation.
One last thing I could point out would be that he was on supervision for approximately 2 years, and during that time period, I don't believe he received any misconduct. There were no graduated interventions and sanctions utilized.
Thank you. Mr. Wright, being that this is your second violation, criminal violation, as well as you were in the community for 2 years and received no misconducts, I recommend revoke and re-parole on May 27th, 2025, which is a 6-month sanction, approximate 6-month sanction with the following conditions: no consumption of alcohol, domestic violence, no contact with victim CD. You have no contact with ED without the express permission of your parole officer. Adrenal no contact with YC or 157 Clark Street in New Britain. Halfway house placement in the event that it is needed. Mental health evaluation and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive the official written decision from the board, and your board review is scheduled on February 13th, 2025. On that date, the board's going to take a look at your case. They can agree with my recommendation, they can lessen my recommendation, or they can exceed my recommendation, being that you are on supervision until March 2026. If they do exceed my recommendation, another hearing would take place. But on the 13th, they make their final decision, and you will receive written documentation of the board's final decision. Okay?
Okay.
Mr. Wright, if you want to call me after the 13th, I can tell you what happened, okay?
Okay.
All right.
So I'll call you after the 13th?
Yeah, because it's going to be the morning of the 13th. So if you want to call me either later in that day or the next day was probably better.
All right.
Okay?
All right.
Okay.
Thank you. You're all set.
All right. Good
All
luck.
right. Thank you. Thank you.
All set?
Yeah.
Matt, could you open that door for me, please? Thank you. Here you go. You're welcome. I have Mathis here if you want him next, or Santana.
Let me see if his attorney is available. Just give me 1 second.
Okay.
I just want to make sure she got my waiver on another guy. That's at the very end. Appeal Saunders?
Yes.
I just want to check with you. So I had Oshane Ellis, and that was a waiver that was submitted yesterday. Did you receive that?
I received that. I'll double check with Officer Williams to make sure he didn't come up because he wasn't on their schedule. So I'll just make sure he wasn't for Osborn. Osborn didn't receive the updated copy because
isn't he at HCC? Oh no,
no, he transferred.
Osborn. You're right. Okay, so let me just check. Let her know. What's her name? Williams?
Yes.
Thea Williams?
Yes.
I just want to confirm that Oshane Ellis does not need to be seen. Do you have him down?
I do not have his name on my docket.
Oh, okay. Okay.
It's good. So we don't need him. We just want to make sure that you guys didn't bring him up because we don't need him to come up.
Okay.
For now.
All right. Thank you.
You're welcome.
Yeah, we're ready for Mr. Mathis.
Okay, Mathis.
You have April 20.
Good morning.
Good morning.
My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Brian Mathis, inmate number 372016. Today is Tuesday, February 4th, 2025. This hearing is being conducted via video of the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Brian Mathis, 372016.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Attorney Alfonzo Sirica, public defender with the Parole Revocation Unit on behalf of Mr. Mathis this morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there's preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Mathis, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state, your parole officers, bringing against you and the information underlying each charge. Charge 1, obedience to the law. On October 17, 2024, you committed an act that is in violation of Connecticut General Statute 53A-96, unlawful restraint second, and Connecticut General Statute 53A-61, assault third on a pregnant person, and Connecticut General Statute 53A-182, disorderly conduct. Video footage from a neighbor's Ring camera shows you following the victim up a flight of stairs, then pushed her against the wall, demanding her to open her apartment door. You continued to stand in the victim's face and would not back up or let her get by. You then proceeded to grab the victim and began pulling and pushing her into the apartment. You then successfully got her into the apartment by force, and you both fall onto the ground. Charge 2, halfway house placement. On October 17, 2024, from 8:30 a.m. to 11:30 a.m., you signed out on an approved community pass to 77 Bishop Street in Waterbury, Connecticut. However, you were found to be unaccountable in the community when Middletown PD was dispatched to a residence on Ferry Street in Middletown. After receiving a call from a nearby resident, the male fitting your description was attempting to break into their neighbor's apartment. You were then observed on camera assaulting a female and attempting to open her door. You did not have authorization to be in Middletown. This is in direct violation of your halfway house agreement. The state has filed the following exhibits. Exhibit A, parole violation notice. Exhibit B, parole PCS conditions. Exhibit C, halfway house agreement. Exhibit D, Middletown Police Report. Exhibit E, Bishop House Incident Report. Exhibit F, Remand to Custody Order. Exhibit G, Parolee Rights. And Exhibit F, Video Footage. The state has filed an addendum to the PVR, which states on January 6, 2025, Mr. Mathis was convicted of disorderly conduct and sentenced to 30 days jail. The charges unlawful restraint second and assault third on a pregnant person was not lead. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
So just quickly on the first part of the hearing, on the charge number 1, that addendum, that is correct. I just want to make sure the record is clear. I understand what the original charges were on the parole violation report on unlawful restraint second, assault third on a pregnant person, and disorderly conduct. And as you just put the addendum on the record, the assault third / on a pregnant person and the unlawful restraint, all those charges were not lead. My client was convicted of a disorderly conduct, which is a Class C misdemeanor, and it carries a max sentence of 90 days in jail, and they gave him 30 days to serve. So I just want the record to reflect. I understand what the initial charges were, but obviously when it goes to court and the prosecutor looked at the video and they took statements from the alleged victims and things of that nature, my client received 30 days on a disorderly conduct. Those are my brief comments regarding the first part of the hearing.
Thank you. I'm just going to take a moment before I announce my findings. On charge 1, obedience to the law, I make a finding based on Mr. Mathis' conviction as well as state's exhibits B, D, and F. On charge 2, halfway house placement, I make a finding based on state's exhibits B, C, D, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, on behalf of Mr. Mathis, my client he's 31 years old. It's my understanding this is his first violation. He did report to us. He did graduate from East Hartford High School. Did complete some general studies college courses at Capital Community College in Hartford. He was out looking for work. He did report to us he attempted to establish dual diagnosis outpatient services in the community. Unfortunately, his insurance was inactive, but he did do a intake assessment. He did establish his primary care services in Hartford. He did recently have surgery on his hand. He's previously has a history of volunteering at the Institute for Community Research and several shelters and food banks in the local community. He does attend AA meetings twice weekly at Osborn. He's amenable to being placed in a halfway house in Waterbury, and he does wish to enroll in tractor trailing school and obtain his CDLA license. And would like to enroll in a drug and alcohol recovery counsel program at DARC. And he's indicated to us he was previously working at world-class distribution Trader Joe's in Bloomfield. He's eligible to return there and is amenable to any job opportunities and all treatment recommendations. It looks like while he was out in the community, he was involved in treatment. Thank you.
Thank you. I'm going to take a moment before I announce my recommendation. Mr. Mathis, being that this is your first violation on parole, you're on discretionary, and you were in the community for only about 23 days, and within those 23 days, you did commit an offense that resulted in your conviction. You received one misconduct for being unaccountable in the community and being in another town without permission. Taking that all into account, I recommend revoke with no new re-parole date, which is an approximate 6-month sanction. In the event that the board chooses to lessen my recommended sanction, I recommend the following conditions: no consumption of alcohol, domestic violence, no contact with victims JB, general no contact with TL, halfway house placement, mental health evaluation. And being that you do have 2-year special parole to follow, I also recommend those conditions for your special parole term as well. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on February 13th, 2025. So on February 13th, the board is going to take a look at your case. They can lessen my recommended sanction, or they can agree with my recommended sanction. If they do.
What's the 6-month sanction? What's that?
That's for the parole violation. That's so giving you a 6-month sanction and tied it to your EOS date of 4/22/25. So once it's going to the board, Brian, on February 13th, they have to give it final approval, as I indicated to you.
A sanction as in what, though? I don't get it.
For violating your conditions of your parole.
So
You had the court case. You were remanded on your discretionary parole.
Yeah.
So the sanction for violating your conditions of parole is a 6-month sanction, but it coincides with your EOS date on your parole.
So, 6-month sanction, like as in what? Like 6-month jail time? I don't get it.
No. April 22nd, you're done. They call it a sanction. You're not getting, it's your time you were remanded. So on April 20, if the board adopts the recommendation, Brian, as I explained to you, April 22nd, you're done with the discretionary parole, and then you start your special parole. So it can't go beyond April 22nd.
All right.
Understand? Okay. And one last thing, that discussion we had via telephone yesterday, those documents went in the mail yesterday. Okay. So you should be getting those soon.
All right. Thank you.
All right. Good luck to you.
All right.
Santana?
Morning.
Good morning, Mr. Santana.
How you doing?
Good. I just have to get your PO on the phone, so just give me a moment.
Yeah.
P.O. Saunders?
Santana.
Yes.
No. P.O. Saunders, that's the hearing examiner. Good morning, Mr. Santana.
How you doing? How you doing?
Good. This is a top referral, correct, P.O. Saunders?
This is, yes.
Thank you.
PO fam, are you there?
Good morning.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Lisis Santana, 246709. Today is Tuesday, February 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office at Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Lisis Santana, 246709.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Sorry, I just got an email that popped up from my boss. Public Defender Rob Famiglietti of the Parole Revocation Unit.
Thank you. And also present this morning is your parole officer.
Good morning, Parole Officer Pham.
This is a preliminary hearing which has three purposes under Connecticut law: to determine if there's probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you have been deferred by the Department of Correction for a diversion for substance abuse programming and treatment. If at the end of this hearing, I determine that you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Santana and PO fam, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Yes.
Thank you. Thank you.
Can I just ask my client a question before we go forward?
Yes. Mhm.
So Mr. Santana, as this is a top referral, we could waive the initial portion of the hearing and just go right to the top referral. Do you wish to do that?
Yes.
Okay, we're going to waive the initial probable cause finding of the hearing and go right to the top portion of it.
Okay. Before I accept the waiver, I just have to make sure Mr. Santana understands the rights he's waiving.
Perfect.
Mr. Santana, you're waiving the right to be represented by attorney, although you have attorney representation. You're waiving the right to receive written notice of charges of violation. You're waiving the right to review the evidence against you before this hearing. You're waiving the right to submit evidence in support of your case. You're also waiving the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand the rights you are waiving here today?
Yes.
I will accept the waiver. I have reviewed your case and made findings of probable cause that you have violated one or more of the conditions of your parole, and I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. I will now proceed with the second part of this hearing regarding the diversion process. The Department of Correction has recommended you for diversion from the revocation process for substance abuse programming and treatment. This means that if you wish to participate and apply, and I find that you meet certain eligibility criteria, I can continue your case while you are provided an opportunity to participate in substance abuse programs and treatment in a correctional facility. If you successfully complete the programs and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the program and treatment provided, the board will schedule and convene a revocation hearing to determine if you violate the conditions of parole. If so, a hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process, and do you wish to apply for diversion?
Yes.
I will now announce my findings with respect to your eligibility. If I determine that you are eligible, I can accept your application and divert you from revocation. I have reviewed all relevant information, and my findings are as follows. I find that you have no pending misdemeanor or felony charges. I find that your discharge date is more than 60 business days from the date of remand to actual custody. I find that there is evidence that you have identified substance abuse treatment needs. I find that your substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of parole. And I find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. I have determined that you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask that you indicate whether you understand the following by answering yes or no.
Yes.
I understand that you will remain incarcerated while I understand that I will remain incarcerated while I receive programming and treatment, and that the parole revocation proceedings may be delayed as a result.
Yes.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes,
I understand that ultimately the Department of Correction will determine whether I have successfully completed the substance abuse programming and treatment provided.
yes,
I understand that my participation in this process is completely voluntary.
yes,
Your application for diversion is granted. You will be placed in a treatment or programming by the Department of Correction and diverted from the revocation process for no more than 60 business days. This now concludes the preliminary hearing. I know you're already in the top program, I believe.
yes, yes,
Yes,
yes, I'm
so
already
you'll
on.
continue to be in the program as long as you successfully
All right.
complete, you would, your parole will be reinstated within 60 business
All
days.
right, all right, thanks.
Sir, good luck. Obey all the rules and guidelines of the program, and everything will work out fine for you. I wish you
All right.
well in the future, okay?
Thank you, thank you,
Thank you. Good day.
thank you. Bye.
Thank you, PO Farm.
Thank you. Bye-bye.
Take care. Have a good one.
Thank you. Have a good day.
Thank you.
Have a good day, hearing examiner Saunders.
You as well, Attorney Famiglietti. Thank you.
Take care. Hopefully that helps you along.
Thanks.
You're welcome.
Good morning.
Morning.
I should have Mr. Harrison.
Yeah, he's finishing up chow. He's coming down on his way.
Sounds good. Thank you.
All right. He was actually in the kitchen, so I got him coming down now. Sorry.
No worries, thank you.
Yep.
Hello.
Good morning, Mr. Frazier.
Hi.
Mr. Harrison, sorry.
Aside.
Good morning, my name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Frasier Harrison, inmate number 151097. Today is Tuesday, February 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Cybulski Correctional Institution. Please state your full name and DOC inmate number for the record.
Name Frasier Harrison, number 151097.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Harrison, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will
Hey,
review.
Liz,
Yeah, go ahead.
didn't we do this before?
So yes, I did hear you before for your preliminary hearing. I know at that time you said you wanted to just go to the end of sentence, correct?
Yeah, I'm good. I got like 49 days left.
So are you saying you want to waive this hearing as well?
I'm gonna waive all that. Yeah, I'm discharging in 49 days.
Okay, so what I'll do is I just want to make sure I'm going to read you your rights that you're waiving here today. So I'm just going to read those rights, and as long as you agree, then I'll accept your waiver, and then I'll conclude the hearing for today. Okay.
Yeah.
So you're waiving the right to be represented by an attorney. You're waiving the right to receive written notice with charges of violation. You are waiving the right to review the evidence against you before this hearing. You're waiving the right to submit evidence in support of your case. And you're waiving the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand the rights you're waiving here today?
Yes, I do.
Okay, so I will accept your waiver, and I'll send you everything in writing. So I still do have to make a recommendation in terms of a sanction, but you'll get all of that in writing.
All right.
All right, thank you. You're all set.
All right, thanks. Yeah. Hey, I'll let you go.
You're welcome. Good morning.
Good morning,
What's your name?
Davis. Tommy.
Great. Do you know if any other individuals available? Or you're the,
It's just me, ma'am.
can you grab the CO really quick for me?
Yes, ma'am. Yes, ma'am.
So Mendez is on his way and Riles is at court.
Okay, awesome. So we'll start with Tommy then. Thank you, Mr. Davis. Thank you. All right. All right, Mr. Davis, I'm going to be contacting your PO, so just give me a moment.
Yes, ma'am.
PO Barstow? I believe you have to pay for, oh yeah, you got it. Are you there?
Hey, good morning.
Good morning. I have
How
Mr.
are
Davis here. Good, so we're gonna get started.
Okay.
Good morning, my name is Pro Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Tommy Davis Jr., inmate number 399290. Today is Tuesday, February 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office and New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
Tommy Davis, 399290.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your parole officer.
Hey, good morning. Parole Officer Barstow, Special Management Unit, New Haven and Bridgeport Parole.
This is a preliminary hearing which has three purposes under Connecticut law. To determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Davis and P.O. Barstow, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you.
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No. No,
You
ma'am.
have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
I'll proceed without counsel.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges of the state your parole officers bring against you and the information underlying each charge. P.O. Barstow, starting with charge 1, reporting.
Good morning. Yes, charge 1, reporting. You are instructed to report on January 13th, 2025 at 1 p.m. You were aware of your reporting instructions as you spoke to this writer via cell phone call at 11:49 a.m. However, you failed to report. Charge number 2, program participation. On October 31st, 2024, you enrolled at the Connection Inc. New Haven REACH program. On 10/31/24, you signed the Connection Inc. client participation contract for the REACH program, indicating that you understand the rules and agree to participate in the REACH program. On December 17th, 2024, you were issued a misconduct for violating the REACH client participation contract. You violated the client participation contract when you admitted to having a verbal altercation with your REACH roommate and admitted to threatening your roommate. This is a direct violation of the Connection Inc. client participation contract. Quote, clients are expected to act in a respectful manner to peers as well as staff at all times. Violence and threatening is not tolerated. Charge number 3, no contact with minors. On February 23rd, 2024, you initialed and signed your parole agreement, specifically special condition, no contact with minors. On 12/25/24, you had in-person contact with a minor child without the express permission of your parole officer. On January 14th, 2025, you wrote a statement admitting that you had contact with minors. You identified the unknown minor in the pictures as your daughter, who was under the age of 16. This is a direct violation of your BOPP stipulated condition of no contact with minors.
The state has filed the following exhibits. P.O. Barstow, starting with Exhibit A.
Okay, yep, Exhibit A, remand to custody. Exhibit B, parole agreement dated February 2024. Exhibit C, the Connection Inc. client participation contract for the REACH program. Exhibit D, misconduct dated 12/17/24. Exhibit E, cell phone picture with minor number 1. Exhibit F, cell phone picture with minor number 2. Exhibit G, cell phone picture with minor number 3. Exhibit H, cell phone picture with minor number 4. Exhibit I, inmate interview statement, handwritten, CN 6609. Exhibit J, DCF email correspondence with DCF Special Investigations. Exhibit K, DCF email correspondence with DCF Social Worker. Exhibit L, misconduct dated 1/14/25. Exhibit M, the notice of parole violation. And Exhibit N, parole violation report.
Mr. Davis, did you receive the parole violation report and the other documents that were just marked for identification purposes? It should have been like a parole package. Okay.
Yes, ma'am.
And did you have time to review it?
Yes, ma'am, I did.
Okay. Today we have no witnesses, and at this time, the state will have an opportunity to make a short statement and testify with respect to probable cause and the severity of the allegation. P.O. Barstow?
Yes.
Would you like to make
nothing further. No, nothing further at this time.
Okay. Mr. Davis, it's now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
Yes, ma'am, I do. So, the misconduct against my roommate, my PO understands that situation. My roommate came in the house belligerent, drunk. I have the video. I tried to show my PO. He didn't want to see it at the time. I showed the house, Mark, who is in charge of the REACH program, the landlord. He was beating on his girlfriend, and I broke the fight up, and I made them separate and leave. That was that misconduct. He said it was just a verbal misconduct, that everything was all right. Next, I want to touch on me not reporting. My father was on life support. I just found out, and I had to go to Waterbury, Connecticut to take my father off of life support. And P.O. Barstow knows that, and he told me as we spoke, every time he called me, I picked up. And I had just found out my father was dying. I'm his only child. I'm the only one that can make the decision. So I told P.O. Barstow, I sent him a picture of my father dying in the bed. And I said, I'm taking him off of life support. I don't drive. I don't have a car. I got driven by my family. So I told him, I said, I'm making the decision. I'm coming right now. I didn't know I was going to be violated. I didn't know what was going on. So he said I had to sign a stimulus to sign something. I said, okay, I'll be there in a minute. You know, he just moved me down to 3 months minimum security. He just moved me down there. So I was seeing him every 3 months. I haven't been in trouble over 5 years. He called me and asked me where I was at around 1 o'clock. I said, I'm on my way now. He said, all right. He called back and then he said, where are you? I said, I'm almost there. He said, you know what? Come tomorrow morning. I said, yes, sir. I reported at 8:30 the next day, which was January 14th. And I got recommended. They locked me up then. My father, like I said, my father was on life support. He understands I had to take my father off of life support. My misconduct that got me here, and I admit 100%. I did not know that my daughter was going to be present at the home. So I was told that I was able to drop presents off from the mother, my fiance's mother, who has custody of my daughter. So I dropped the presents off. Her sister opened up the door and she let me take a Christmas picture with my daughter. And that was it. That's all I did. I haven't been in trouble in over 5 years. No new charges, no criminal charges, no dirty urines, nothing. I've been working. I have a good job. I work for Layden Industries. I work for G-Force Paving. I got my certified flaggers. I got my OSHA. I haven't got in no trouble. This is my first time in over 5 years. Over 5 years. My PO told me on my way here to prison that he recommended me to get on a bracelet to come home. But as I read the evidence, that's not what he recommended. He said I had zero regards for parole, which is mind-boggling because that's not what he told me and my family. And it hurt me because he knew what I was going through with my father. He knew that. He said he feels what I'm going through. He understands what I'm going through, and that he had recommended for me to come home on a bracelet. It's been over 5 years. No criminal charges, no nothing. I've been sick here. I caught COVID-19. I'm sick. I've been going through everything here. I've been going through a lot. I don't know what's going to happen to my father. I'm the only one that can bury him. I can't do nothing, you know? I haven't been in no trouble. I took a picture with my daughter. It was Christmas. I made a mistake. I should have went through DCF. I understand that. I spoke to the special investigator yesterday, and he understood where I was coming from. And he said, you know, I wish you the best with your parent because it's not fair. It's not right. I did not know my daughter was going to be present. It wasn't a planned visit. It wasn't pre-planned. They just tried it. It was good. It was good intentions, but a bad choice, you know? And that's exactly what it is. And like I said, I've been in here suffering. I've been sick. I don't know what's going on with my father. I'm just trying to get back home, get back to my family and continue to do the right thing. You know, if I would have let like I said, touching back on my first misconduct with my roommate, if I would have let him beat his girlfriend up, then I would have been in trouble for sitting there not doing nothing. I did everything right. I broke the fight up. I said, if you could hit a girl, you could hit me. Don't put your hands on that woman. You know what? He had it choked up. I had the whole video. And like I said, I tried to show my PO. He did not want to see it. So that was that. I couldn't even believe he put that in the misconduct with me going down to the Waterbury Hospital to take my father off of life support. That broke my heart because he knew what I was going through. He knew my father was dying. I didn't even know. I found out 3 days that my father was dying. And I had to go make a decision. And I'm all the way in Waterbury, Connecticut. And I still broke away from what I was doing to make it down here. And then he tells me, never mind, come in the morning. And that's exactly what I did. And for him to say I got zero regards for parole is out of this world because you just moved me down to 3 months supervision minimum. I was doing that good. He just moved after the misconduct with my roommate. He moved me down to 3 months. So how bad was I doing? You know what I'm saying? I've been doing great. I've been doing everything that I'm supposed to do. I haven't caused any trouble. I haven't caught no new charges in over 5 years. Nothing. You know, I'm sitting here in this jail. I see people coming back. Oh, yeah, I just got off for special. I just robbed the bank. I did this. And these people are coming back and forth. That's not me. You know, I took a picture with my daughter. Yes, that's my daughter. You know, any father would, you know. And yes, I should have went through DCF, but I'm not no threat. I didn't hurt my daughter. I took a picture and I left, you know. And all I'm trying to do is get back home to my family and to my father so I can bury him. I'm his only child. He has nobody. He's just sitting in the freezer. And that's why it hurt me when I seen the evidence and I read that I didn't come to parole. He told me, never mind. He knew I was taking my father off of life support. So why would you even put that in there? You know, that hurt me. And then if I would have let my roommate beat on his woman, I would have been in the wrong for letting him beat on that woman. I stopped him. I said, don't put your hands on that woman. I didn't threaten him with no like physical violence. I said, if you can hit a woman, you can hit me. Hit me, take it out on me. And I had the whole video. And the Reach program director, he was so hurt, he couldn't believe that they even violated me. He said that was so wrong. He loved me there. He loved me. I did everything I was supposed to do. Everything for 5 years working. No trouble, no dirty urines, no new charges, nothing. Nothing, ma'am, nothing. You know what I'm saying? And I've been sitting here going through it. I mean, this facility is crazy. I've been sick with COVID. I got heart problems. I was just ran over by a car at work. I'm in pain. I'm just trying to get home back to my doctor's appointments and things like that. So me sitting here, this time that I've been sitting here, I learned, I'm telling you, I learned a lot. I do not want to be back in jail for nothing else ever again. You know what I'm saying? I am in the wrong for, you know, I should have went through DCF. That was my only mistake, just taking a picture with my daughter on Christmas. That was my only mistake. And I'm pretty sure you heard way worse than this, 100 times worse than this. So like I said, I understand I did wrong, but I done learned my lesson. I've been sitting here this whole time. This is a long time that I've been sitting here since January 14th. Is that we're already in February. And my father just sitting in a freezer, man. He's just sitting in a freezer. And that's just breaking my heart because he knows that. And I never missed parole. Never since I've been home, I missed parole, ever. And he just got me October 31st of 2024, which was the day of my daughter's birthday. Did I go over there? No, I didn't go there. I stayed home. I followed parole rules. I sat there. Her first birthday. Didn't go nowhere. I sat in the house. You know, I don't have zero disregard for parole because if I did, I would have violated already. It's been over 5 years. Nothing. No new criminal charges, nothing, man. Nothing. I just want to get back home. That's it. And that's all I got to say. Thank you so much for your time.
Thank you. P.O. Barstow, is there anything further you would like to state?
I would just like to cite one piece of evidence regarding the no contact with minors. This would be Exhibit K, DCF email correspondence with his assigned DCF social worker, who's Lisa Miller. I just want to read this email. Good morning, Mr. Christopher Barstow. Please be aware that Tommy Davis was not approved or authorized by the Department of Children and Families to have unsupervised visit with Desiree Davis. Tommy was scheduled to resume his supervised visits at the DCF office in New Haven every Thursday from 10 to 11 a.m. starting on 12/12/24. Tommy was a no-call, no-show for every visit. Prior to Tommy moving to New Haven, Tommy refused supervised visits at the Waterbury office. His reason, quote, he does not like the office. And on 1/2/25 during a court hearing, Tommy interrupted the hearing to ask that the mother of Ashley supervise him. The judge told him he can only have supervised visits with Desiree by the department.
Can I speak on that or?
Well, I just wanted to make sure, is there anything else you would like to say, P.O. Barstow?
No, this is it. This is it, right?
Okay.
So, ma'am, so me not going to the office, like I said, I was in Waterbury. I had a parole officer in Waterbury. Her rules was different from his rules. Okay, the office that my daughter was in, they had us in a small box room. I went to every visit until they started letting because I got approved to see my daughter. My daughter was supposed to come home to me, and my fiance was my sponsor until they found drugs in her system, and then she was no longer my sponsor. Okay, part of my plea agreement is that I could be around my biological children. That's in my transcripts. That's in the court document of this case. When DCF got involved, things started getting twisted up. I told him I didn't want to go to the office no more because my daughter's sitting in the office in a small room, we in a box like a jail cell, and she's screaming on the top of her lungs. And they started letting my fiance, Ashley, the mother, do outside visits where she get to bring her outside and go to the park and stuff like that. And I asked, can I get that? My lawyer, Julia Burt, who's in charge, said she was in the process of getting that done for me. So I said, I don't want to have my daughter keep coming down from New Haven, Connecticut to Waterbury. I moved to New Haven. When I got to New Haven, I had zero transportation, no way to get to the office. I never lived in New Haven before. I don't know where the place is. So we had a video conference with the court. Barstow was present. He spoke highly of me. oh, he's a great person. He's a great guy. He's doing everything he's supposed to. I'm moving him down in 3 months. He's doing good. They just got me set to where they was going to give me a bus pass, or they was going to get me transportation. That's what was last said, and that's what we was going off of. And I was perfectly fine with that. I said, if that's what I got to do, they said, plus the building is huge. You get to do way more things with your daughter. And I said, that's awesome. I would love to do that. And then I got arrested. I didn't get a chance. You know, so it wasn't, I was just disregarding my daughter. No way I would ever do that, ever. I just didn't have transportation in New Haven, and the place is far from where I live, and I had no way to get there. You know?
Anything further?
No, man.
Okay. And P.O. Barstow?
No, all set.
Okay. I'm just going to take a brief recess before I announce my findings.
Yes.
Oh, he's here to find out? Yeah, he already, all right, I need to find somebody to. He just got here? Is there anybody who would be in video conference so I can on the arm? Reports on that. He's got here for the environment. I just got a next interview. All right. Thank you. Okay, we are now back on the record. Regarding, before I make my findings, is there anything else, P.O. Barstow, you would like to state?
No, thank you.
And Mr. Davis, you're all set as well?
Yes, ma'am. Yes, ma'am.
On charge 1, reporting, I make a no finding of probable cause as the state failed to provide sufficient evidence to prove that Mr. Davis' actions meet the elements of this charge. On charge 2, program participation, I make a no finding of probable cause as the state failed to provide sufficient evidence to prove Mr. Davis' actions meet the elements of this charge. On charge 3, no contact with minors, I make a finding of probable cause based on state's exhibits B, I, J, K, and N. I find that the acts are not serious enough to warrant revocation. As such, your parole will be reinstated today. Mr. Davis, what is your release plan? Where do you have a sponsor, a place to go? Are you in a halfway house? What is your plan?
They said I can get my room back at the REACH program.
Okay, so I don't know if you'll be able to go there today.
That's not possible. That's not, the REACH beds are no longer available.
Well, I have a sponsor then. I have a sponsor.
So I'll take your sponsor information, but you'll probably end up in a halfway house because for today, until your parole officer is able to do the checks and all that. So I need an area of a halfway house.
Okay.
You're thinking?
For me, a halfway house?
Yeah, I need an area.
You could put me back in New Haven.
New Haven, okay.
Yes.
And then your sponsor, who would be your sponsor?
My sponsor is Patrick. P.O. Barstow have all his information. It's 26 Fortune Drive, New Haven, Connecticut.
Patrick, what's his last name?
P.O. Barstow. What is his last name? It's my fiance's brother-in-law. He said I can go.
We tried to make contact with him multiple times. He never returned any of my calls. So that previous residence had been marked invalid because of lack of contact. But I believe it's Chandler, and it's his
yes
spouse's
Chandler.
brother-in-law.
His phone was off.
Okay. So I'm gonna put in my report. This is your plan, but P.O. Barstow already said it's not valid. I'm gonna write up everything. So your release plan would have been Patrick Chandler at 26 what drive? What was the street name?
Fortune Drive, Fortune.
Okay. So in terms of your parole being reinstated today, your same parole conditions go back into place. And you'll go to a halfway house and hopefully in the New Haven area. Okay.
God bless you. God bless you so much. Thank you, man.
This concludes your preliminary hearing. You're all set.
Thank you, man. Thank you so much. Thank you.
Thank you, P.O. Barstow.
Yep, take care.
Hey, today. Wait, oh.
Yes. Well, I know. Good morning or good afternoon, Mr. Mendez.
Good afternoon, Miss.
I need 5 minutes, okay? 5 minutes.
Perfect.
Thank you, I appreciate it.
Thank you, Quinn.
Okay, Mr. Mendez.
Okay,
I'm going to talk to the interpreter for 1 second. So one
Okay.
moment. Speak to the interpreter. Good afternoon, Liza Rivera. Please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that you will faithfully discharge, according to law, your duties as an interpreter to the best of your abilities, so help you God, or upon penalty of perjury?
I do.
Thank you. Good afternoon. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Miguel Mendes, inmate number 343668. Today is Tuesday, February 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in New Haven Correctional Center.
Buenos días, soy la oficial Saunders, examinadora de audiencias para la Junta de Indultos y Libertad Condicional. Esta es una audiencia de revocación referente a Miguel Mendes, número 343668. Hoy es martes 4 de febrero del 2025 y esta audiencia se está llevando a cabo a través del video en la Junta de Indultos y Libertad Condicional, localidad central y el Centro Correccional de New Haven.
Please state your full name and DOC inmate number for the record.
Por favor, decir su nombre y número de DOC para el registro.
Miguel Mendes, 343668.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Hi, good morning. Hannah Dean on behalf of Mr. Mendez.
Esta es una audiencia pública, acceso público a esta audiencia está disponible vía transmisión en vivo.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement.
Esta es una audiencia de revocación para determinar si ha violado las condiciones de su liberación. Revisaré y haré hallazgos de hecho en cada uno de los cargos en su contra. El Estado, no usted, tiene la responsabilidad de probar las acusaciones mediante una preponderancia de evidencia. Es decir, la mejor evidencia o más pesada debe establecer que más probable que no la alegación es cierta. Si no encuentro que haya una preponderancia de evidencia que respalde una violación, una o más de las condiciones de su libertad condicional, estableceré la libertad condicional, lo que significa liberarlo y ponerlo bajo supervisión nuevamente. Si encuentro que ha violado una o más de las condiciones de su libertad condicional, consideraré si su libertad condicional debe ser revocada o no. Si recomiendo la revocación, haré una recomendación en cuanto a una sanción apropiada. Mi recomendación se dará a un panel para una decisión final. Si el panel desea imponer una sanción más allá de mi recomendación, se proporcionará una audiencia suplementaria para justificar un confinamiento adicional.
The testimony of today's hearing will be taken under oath. Mr. Mendez, please raise your right hand.
El testimonio del día de hoy será tomado bajo juramento. Señor Méndez, por favor, levante su mano derecha.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or penalty of perjury?
Usted jura solemnemente y sinceramente afirma, según sea el caso, que la evidencia provista en este caso será la verdad, toda la verdad y nada más que la verdad, que así lo ayude Dios o bajo penalidad de perjurio.
Ok, está bien.
Okay, thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Ahora le voy a hablar acerca del procedimiento de la audiencia. Primero voy a leer sus derechos, luego revisaré los cargos de la violación de libertad condicional que el oficial de supervisión ha presentado en su contra. Luego revisaré e identificaré la evidencia presentada para el registro. La defensa tendrá la oportunidad de presentar testimonio relevante sujeto a contrainterrogatorio. Luego de considerar la evidencia presentada, anunciaré mis hallazgos. Si encuentra que usted ha violado una o más de las condiciones de su libertad condicional, su abogado tendrá la oportunidad de hablar acerca de sus antecedentes e historial. ¿Tiene alguna pregunta antes de comenzar?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Usted tiene derecho a ser representado por un abogado en esta audiencia. Usted tiene derecho a recibir una notificación por escrito de los cargos de violación. Usted tiene el derecho de revisar la evidencia en su contra antes de esta audiencia. Usted tiene el derecho a presentar pruebas en apoyo de su caso. En esta audiencia usted tiene el derecho de llamar e interrogar a testigos voluntarios y de interrogar a testigos adversos. ¿Entiende usted estos derechos?
Sí.
Yes.
No questions, right? Yeah, okay. We would now review the charges of the state your officers bringing against you and the information underlying each charge.
Estaremos ahora revisando los cargos que el Estado ha presentado en su contra y la información subyacente a cada cargo.
Charge 1, drugs. On or around July 13th, 2024, you used cocaine and fentanyl that resulted in an overdose. You were found at 4:35 a.m. unconscious in the stall of the bathroom. You were administered 3 doses of Narcan until you became alert, transferred to Yale New Haven ER. On or around July 22nd, 2024, you used cocaine and fentanyl. On or around August 9th, 2024, you used cocaine. On or around November 6th, 2024, you used cocaine and fentanyl. On or around November 15th, 2024, you used cocaine and fentanyl.
En el cargo número 1, drogas. En o alrededor del 13 de julio del 2024, usted usó cocaína y fentanyl, que resultó en una sobredosis. Usted fue encontrado a las 4:35 de la mañana inconsciente en el cubículo del baño. A usted se le administraron 3 dosis de Narcan hasta que usted se mostró alerta y fue transportado a la sala de emergencias de Yale New Haven. En o alrededor del 22 de julio del 2024, usted usó cocaína y fentanyl. En o alrededor del 9 de agosto del 2024, usted usó cocaína. En o alrededor del 6 de noviembre del 2024, usted usó cocaína y fentanyl. En o alrededor del 15 de noviembre del 2024, usted usó cocaína y fentanyl.
Charge 2, halfway house placement. On or around July 22nd, 2024, August 9th, 2024, November 6th, 2024, and November 15th, 2024, you violated your signed halfway house agreement. Most specifically, I will not use, possess, sell, transport, or in any way have contact with illegal drugs or prescription drugs that are not prescribed to me by a licensed physician.
En el cargo número 2, ubicación en halfway house. En o alrededor del julio 22 del 2024, agosto 9 del 2024, noviembre 6 del 2024 y noviembre 15 del 2024, usted violó su acuerdo firmado del halfway house, el cual establece: no usaré, poseeré, transportaré o tendré algún tipo de contacto con drogas ilegales o drogas prescritas que no hayan sido recetadas por un médico licenciado.
The state's exhibits were marked and identified at the preliminary hearing held on December 17th, 2024. PCS filed an addendum that states Mr. Mendez does not qualify for the top program due to him being a level 4. PCS requested for BOP to proceed with a revocation hearing for a full technical violation. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, I have. El Estado proveyó la siguiente evidencia para fines de identificación, la cual fue establecida en la audiencia que usted tuvo el 17 de diciembre del 2024. También se recibió el siguiente anexo de PCS, el cual establece Miguel Mendes número 343668. Fue aprobado para el programa de TAP. Sin embargo, Mendes no cualifica ya que está en un nivel 4. PCS quiere proceder con la audiencia de revocación para una violación técnica. A la defensa recibieron el aviso de violación de libertad condicional, reporte de violación a libertad condicional y otros documentos que han sido marcados para propósitos de identificación.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, and today we have no witnesses.
La defensa también ha presentado la exhibición 1, reporte de logros bajo libertad condicional y planes futuros. No tenemos testigos en el día de hoy.
It is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel.
Es ahora la oportunidad de la defensa de hablar acerca de la causa.
Yes, so I just have some general comments as to these charges. This violation really just stems from an unfortunate situation where it's clear that Mr. Mendez was struggling and needed a higher level of care in order to succeed in the community.
Solamente tengo unos comentarios en general acerca de estos cargos. Esta violación está en referencia a una situación muy afortunada donde mi cliente estaba teniendo dificultades afuera en la comunidad.
It appears that Parole had initially tried setting my client up with inpatient treatment by referring him to APT, but to no fault of my client, APT denied his admission due to co-occurring mental health issues that they felt were not stable at the time.
Mr. Mendes había sido evaluado y referido para tomar tratamiento a través de la Fundación APT, por la cual fue denegada ya que establecieron que habían ciertos problemas de salud mental, lo que no es su culpa.
This happened back in July, and thereafter my client did take steps to get his mental health concerns under control. He attended an appointment with his doctor in August where his mental health medications were adjusted.
En el mes de julio, mi cliente tomó los pasos necesarios para poder trabajar con la situación de salud mental y también tuvo una cita en el mes de agosto para trabajar con esto.
Despite this decision from APT to not admit him, other inpatient programs were also reportedly considered, but the client's insurance apparently posed some issues, though the PO didn't elaborate what those specific issues were or which programs were contacted for treatment.
A pesar de que la decisión de la Fundación APT fue denegada, mi cliente tomó otros pasos para tratar de considerar tratamiento en otros programas, pero fueron denegados debido a razones por el seguro médico. El oficial de supervisión no estableció cuáles fueron específicamente estos problemas.
Nowhere in the violation paperwork does it suggest that my client was non-compliant with his mental health medications, and in fact, in November, my client's clinician my client indicated that his mental health had been stable for over 30 days. Nevertheless, APT did deny him again, despite him being continually recommended to that higher level of care.
En ningún momento la violación de libertad condicional sugiere que mi cliente no estaba cumpliendo con su recomendación de salud mental o con los medicamentos. Incluso se indicó que él llevaba estable sobre alrededor de 30 días, pero a pesar de esto, la Fundación APT lo denegó nuevamente debido a su nivel.
It doesn't appear at that point that other inpatient options were considered further or discussed, and it doesn't appear that my client was referred anywhere else for treatment. Instead, the decision was made to remand him without that inpatient treatment in hopes that he could utilize the TOP program.
No se ve en ningún otro lugar que él haya sido referido para otro programa de hospitalización, por lo cual él no tenía otras opciones.
However, to no fault of Mr. Mendez, despite TOP being ordered at his preliminary hearing, he was unable to participate due to his level in the facility.
A pesar de que se recomendó que él participara del programa de TAP en la audiencia preliminar, no pudo completar el mismo ya que fue denegado debido a su nivel.
I would just note that incarceration alone without substance use or mental health treatment is not serving my client and isn't helping him move forward with sobriety. And at the appropriate time, I would like to speak to his background and future plans.
Quisiera recalcar que un periodo más prolongado de encarcelación sin tratamiento de salud mental no beneficia a mi cliente y estaré más adelante hablando acerca de sus planes para liberación y libertad condicional.
Thank you. Anything further, counsel?
No.
Okay. Regarding charge 1, drugs, I make a finding based on state's exhibits E through W. On charge 2, halfway house placement, I make a finding based on state's exhibits D through W. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history.
En el cargo número 1, drogas, algún hallazgo basado en la evidencia del Estado, exhibiciones E a W. En el cargo número 2, ubicación en halfway house, algún hallazgo basado en la evidencia del Estado, exhibiciones D a W. Con esto concluye la parte de determinación de hechos de la audiencia. Antes de hacer mi recomendación, la defensa tendrá la oportunidad de hablar sobre sus antecedentes e historia.
My client, Mr. Mendez, is 47 years old, born and raised in Puerto Rico. He moved to Torrington, Connecticut in 2006, and his primary sources of support are his mother, brother, and sister, who all reside in New Britain.
Mi cliente, el señor Mendez, es un hombre de 47 años de edad que fue nacido y criado en Puerto Rico, pero se mudó en el año 2006 para el pueblo de Torrington, Connecticut. Él recibe su apoyo primario por parte de su mamá, su hermano y su hermana, los cuales residen en New Britain, Connecticut.
Upon release to special parole in May of 2024, my client was placed at the Connection Roger Sherman House in New Haven and was there until his remand. While in the community, he received disability assistance for both medical and mental health purposes.
Al salir bajo libertad condicional, mi cliente fue ubicado en el Roger Sherman Halfway House en New Haven. Permaneció participando en este programa hasta haber sido regresado a custodia. También cuando estaba fuera en la comunidad, comenzó a recibir servicios de discapacidad por propósitos médicos y mentales.
From September 5th of this past year to September 26th, my client reports being hospitalized at Yale New Haven's psych unit per his request. He also reports that he met with a doctor and psychiatrist at Cornell Scott Hill in New Haven for treatment. Also was working with a recovery coach from CCAR on a weekly basis.
También mi cliente estuvo desde el 5 de septiembre del 2024 hasta el septiembre del 2024, hospitalizado en una unidad psiquiátrica hospitalizada en el hospital de New Haven. También tuvo una cita y se vio con el psiquiatra, el cual estuvo en la clínica de New Haven, Connecticut. También estuvo participando, trabajó con un facilitador de recuperación de CCAR con el que habló semanalmente en persona y por teléfono.
Since being remanded to New Haven Correctional, my client has been medication compliant, which he finds very helpful. He meets with 2 social workers at the mental health unit and also signed up for programming and employment in the kitchen.
Desde que mi cliente está encarcelado, él está cumpliendo con sus medicamentos, el cual ha encontrado que ha sido muy beneficioso. También está teniendo reuniones con 2 distintos trabajadores sociales en la unidad de salud mental. También está tomando programación y está empleado de la cocina.
Upon reinstatement of special parole, he would like to be sponsored by his mother, Ms. Gonzalez, in New Britain, or as a backup, be at a halfway house in Hartford due to the proximity to family. He's open to any sort of treatment recommended, including dual diagnosis, IOP, stepping down to relapse prevention, medication-assisted treatment in the form of Suboxone, medication management, and then he also wants to go back to working with CCAR.
De ser puesto en libertad condicional, a Mr. Mendez le gustaría ser patrocinado por su mamá, la señora Norma González. También está dispuesto a tener un halfway house como plan alterno. También él está disponible a todas las recomendaciones de tratamiento, incluyendo servicios clínicos de doble diagnóstico, incluyendo un programa intensivo ambulatorio con un servicio de descenso de medicamentos, tratamiento asistido por medicamentos en forma de Suboxone y trabajar con un consejero de CCAR.
My client has been incarcerated for approximately 2.5 months. He's been sober throughout while in the facility. He wants the treatment, he wants help, he wants to get sober. He's looking to re-engage in treatment in the community so he can move forward with recovery. I would just ask that he be given the soonest possible re-parole date.
Mi cliente lleva encarcelado por un periodo de 2 meses y medio. Él se ha mantenido sobrio. Él desea que se le ofrezca tratamiento, desea poder mejorar y continuar el tratamiento para permanecer sobrio en la comunidad.
Anything further?
No, thank you.
Thank you. I'm just going to take a moment before I announce my recommendations.
Voy a tomar un momento antes de anunciar mis recomendaciones.
Good, so I have,
Okay, Mr. Mendez, being that you were in the community for 6 months, this is your first violation. You did receive 5 misconducts, but taking into what your attorney represented here today as well, I recommend revoke and re-parole on February 13th, 2025, which is an approximate 3-month sanction with the following conditions: no consumption of alcohol, halfway house placement, and mental health evaluation.
Mr. Mendes, ya que usted estuvo en la comunidad por un periodo de 6 meses y esta es su primera violación, tuvo 5 reportes de conducta, pero a pesar de esto también tomamos en consideración lo que su defensa habló en el día de hoy. Recomiendo que su libertad condicional sea revocada y restablecida el 13 de febrero del 2025, lo cual es un periodo aproximado de sanción de 3 meses, con las siguientes condiciones: no consumo de alcohol, ubicación en Hartford House y evaluación de salud mental.
My findings and recommendations will be forwarded to the board, and you will receive a written decision from the board, and your board review is scheduled on February 13th, 2025. On that day, the board's going to take a look at your case. If they agree with my recommendation, you will be released that day. If they don't, then they can exceed my recommendation and another hearing will take place.
Mis hallazgos y recomendaciones se emitirán a la Junta. Usted recibirá la decisión oficial por escrito. La revisión de la Junta está programada para el 13 de febrero del 2025. En ese día, si la Junta acepta mi recomendación, usted sería puesto en libertad ese día, y de querer hacer una sanción más larga, entonces se hará otra audiencia.
Okay. Question?
¿Y cuándo es que va a ser libertado? ¿Y para dónde?
¿Cuándo?
¿Que va a ser libertado y para cuándo?
When is that I be released for what date?
So she is recommending February 13th. On that date, the board will look at her recommendation and they can either say yes to the recommendation, they can make it less potentially, or they could make it more. If they make it more, you'll be hearing from me and we'll get another hearing.
Usted está pautado para la recomendación del oficial, fue que usted se ha puesto en libertad para el 13 de febrero del 2025. Ese día, si ellos aceptan la recomendación, usted sería puesto en libertad. De ellos querer establecer una sanción más larga, entonces estarían haciendo, usted va a escuchar acerca de, por parte de la defensa, para entonces tener otra audiencia adicional.
Okay.
Okay. Thank you.
Thank you.
Thank you. Thank
You're
you.
all set. Thank you.
Thank you so much.
Mendez, I'm here.
Officer?
You're good to go.
Officer?
Yes.
I just want to confirm Mr. Riles at court, correct?
Yes,
Okay, thank you. You're CEO Rodriguez. I just want to make sure. Thank you.
yeah, no problem. Bye.
Due to inmate Daniel Riles, inmate number 235288 at court, his case will be continued until February 18th. Kristen, do you mind keep calling for me?
Can do.
Thank you much. Good afternoon.
Good afternoon.
Hi, just looking for Mr. Luis Hernandez.
Luis Hernandez, he's on his way up.
Thank you.
Yep. Hey, who's this? Hey, it's Rivera. Rivera, H. Yeah. Anyways, listen, not much. Mr. Hernandez on 52, but he had a pro visit. Is he on his way up? No. No, because I just got here. I thought Cunningham was here, so I figured he'd call. No? All right, can you send them up? Says. What's his first name? It's not him. Fuck, he had that. All right, thanks.
Yes, 14.
Excuse me. Is Mr. Hernandez
Yes.
in Hartford? Because I
Yeah.
just called over there thinking he was on his way, and there's the Hernandez that I got on this paper doesn't match with the Hernandez in that dorm that they got listed here.
I'm checking right now. Yes, he's in Hartford. Inmate number 291110. He's been there
Right.
since 115, January 15th.
Okay, let me double check because it says dorm A. We don't got an A. We got numbers. So we got dorm 1, 2, 3, and 4. So that's why I called dorm 1, thinking A for 1. But he's not in there. So let me try to locate him. Might take a little longer than 5 minutes because the officer I came to relieve, I guess he didn't call for him.
Okay, because I see here it says housing unit M 52 dorm 4.
So it's dorm 4. Okay, let me call dorm 4 then. Hey, Michelle Rivera. Hey, can you do me a favor and check if you have a Hernandez in bunk 52? What's his inmate number? Yep. Yep. Yeah, that's him. Can you send them up to Pro Visit, please? Yeah. Thank you, ma'am. Okay, we located him, so he's on his way up.
Thank you.
Thank you. Been here since 5 up.
Yeah, they told me that it could take up to 4 o'clock count. I'm like, what? I ain't never had a parole hearing like that. Right here, Papa.
Hi, good afternoon, Mr. Hernandez.
Good morning. Well, good afternoon.
Yes. Good afternoon. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Luis Hernandez, inmate number 291110. Today is Tuesday, February 4th, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Hartford Correctional Center. Please state your full name and DOC inmate number for the record.
Luis Hernandez, 291110.
This is a public hearing. Public access to this hearing is available via video live stream. Mr. Hernandez, I noticed on your parolee rights that you indicated that you did not want to proceed with a preliminary hearing today. Is that still your intent?
Yes.
Or would you like to move forward?
Yes, I'd like to move forward, yes.
Okay. So this is a preliminary hearing which has 3 purposes under Connecticut law. To determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony in today's hearing will be taken under oath. Mr. Hernandez, please raise your right hand. Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your parole officers bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
You have important rights at this hearing, which I now review with you. You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
I would like to proceed without counsel.
You have the right to receive written notice of charges of violation. You have the right to review that evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges of the state your parole officers bringing against you and the information underlying each charge. Charge 1, drugs. On or around December 28th, 2024, you used cocaine. On or around January 3rd, 2025, you used cocaine. Charge 2, halfway house placement. On January 6th, 2025, you signed out of the open hearth halfway house at 8 a.m. to report to CRT for IOP. You returned to the halfway house at 12:33 p.m. Upon investigation, it was discovered that you failed to report to CRT at all on this day, therefore making you unaccountable in the community for 4 hours and 33 minutes. This places you in clear and direct violation of your halfway house agreement. You did not have permission from anyone to be anywhere other than CRT. On January 15th, 2025, during a routine pat search of your person by Parole located a vape pen in your right front pocket. This places you in clear violation of your halfway house agreement. The state has filed the following exhibits. Exhibit A, PCS signed conditions. Exhibit B, halfway house agreement. Exhibit C, Redwood Toxology Laboratory Report. Exhibit D, Redwood Toxology Laboratory Report. Exhibit D, email from Lauren Lagasse at CRT. Exhibit F, Open Hearth Incident Report. Exhibit G, contraband photo. Exhibit H, remand to custody order. Exhibit I, notice of parole violation. Exhibit J, notice of parolee rights. And Exhibit K, parole violation report. Mr. Hernandez, did you receive the notice of parole violation report, and the other documents that I just marked for identification purposes? It should have been a parole package.
Yes, ma'am.
And did you have time to review it?
Yes.
Today we have no witnesses, and it is now your opportunity to respond to the parole charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
Yes, I hold myself accountable for the two dirties. For the one CRT, actually Miss Miller actually had everybody in the house because she was doing her routine checkup with everybody in the halfway house. And if you look in the logbook, I didn't leave at 8 o'clock. I left like around 9:30, 10. And I only went to the store and I came back and I called CRT and told them that I wasn't going to make it because it was going to be late. By the time I made it to the second group, that they were going to, by the time they're going to start the second group, it would be almost finished by the time I get there. I told Miss Miller that, but they still put it in the report anyways. And yes, I did have a cigarette vape in my pocket.
Okay. Anything further?
No, ma'am.
Thank you. I'm going to take a moment before I announce my findings. On charge 1 drugs, I make a finding of probable cause based off of your testimony today, as well as state's exhibits A, C, and D. On charge 2, halfway house placement, I make a finding based off of your testimony today, as well as state's exhibits A, B, E, and F. I find that the acts are serious enough to warrant revocation, and I have also determined that you should be detained while you wait for your revocation hearing. Your revocation hearing will be scheduled within 60 business days from your return to custody. You will receive a hearing disposition, which will have a tentative hearing date listed. Keep in mind, all hearing dates are subject to change. Okay, so your revocation hearing will be scheduled within 60 business days. So you're going to get a disposition that's going to have a date listed. It could be sooner or later than that day, but it has to be before your 60 business days. Okay?
Okay.
So then let's conclude the preliminary hearing and you're all set.
All right. Thank you.
Thank you.
You have a good day.
You too.